submitted for decision, and we'll take the case under advisement and issue a written decision as soon as practicable. Okay, with that, I'll go ahead and call the first case. Our first case this morning is from Johnson County, case number 127967, Stephanie Tucker Muir, appellant, versus Cleveland University in Kansas City and others. So if attorneys could please just go ahead and enter your appearances.
Certainly. May it please the court, Joe Cronenwitter for the appellant plaintiff, Stephanie Tucker Muir.
May it please the court, Catherine O'Shea and Kevin Weekly on behalf of the appellees for the defendants below.
Does appellant wish to reserve time for rebuttal?
I do, Your Honor. Can I reserve 5 minutes for rebuttal?
It's granted. All right. With that, we're ready to proceed.
Thank you, Your Honor. I will start with a brief recap. When I get into the issues, as you saw, the record and the issues are a little convoluted and complex. I may be a little more reliant on an outline today than I would prefer. As a recap, I represent an individual by the name of Stephanie Tucker Muir. She went sledding on the defendant's property in the winter of 2020, 2021, January 2nd, 2021 to be exact. Her first time on the property, she slid down the hill, struck a fire hydrant at the base of the hill and suffered a brain injury. The defendant's property, it's a commercial property that houses a chiropractic college. My client was taken to a hospital. She later sued for premises liability. The case was assigned to Judge Mason here. We went through discovery. The defendants filed a motion for summary judgment, claiming that the Kansas recreational use statute provided immunity from suit. We briefed the issue. Judge Mason entered summary judgment on behalf of the granting it to the defendants. That's how we've arrived here today.
Thank you.
On behalf of my client, Ms. Muir, I asked the court reverse the trial court's decision for 4 specific reasons. First, the district court erred in the manner in which it found the facts to support summary judgment, such as claiming some facts were uncontroverted or uncontested when in actuality, as the briefing shows, they were contested. That's point 1. The second point is that the court erred in finding that the sledding hill was open to the public, which is the key point, when that issue was hotly disputed and contested, including evidence that there were signs on the hill saying there was no trespassing and there was no sledding allowed. The third point is that the trial court erred in determining that, or raising sua sponte, an argument about judicial estoppel that was never raised by the defendants in briefing, including the court doing its own research and citing judicial estoppel cases that my client never had a chance to address, that appeared for the first time in the summary judgment order. And the fourth issue is that our basis for reversal is that the district court erred in finding that the willfulness exception to the recreational use statute did not apply, despite the fact that the Kansas Supreme Court specifically said that summary judgment should be rarely granted when there are issues dealing with state of mind, since determining state of mind is usually a fact issue. That's the fourth point. I guess before we get into those, let me just address that there was a recent submittal under Rule 6.09 by the defendants about the Zaragoza case last week. And for the life of me, I can't understand why that was cited or even submitted to the court. That case dealt with the Kansas Tort Claims Act and an exception under that, the Kansas Tort Claims Act. We're not dealing with that. The defendants, they cited that case for the idea that this court reads recreational use immunity broadly to accomplish the legislative purpose. That's not what Zaragoza said. Zaragoza said that we read this recreational use immunity statute broadly. So it's a completely different statute, completely different set of law. Zaragoza has no applicability or relevance to anything in this case. That case never even cites the recreational use statute we're here to talk about. So on to the first point, this idea that the district court erred in the way it found the facts. We cite this, and I think we did an okay job dealing with this in the brief. I'm not going to rehash all of that. Just to point out that the way the district court found the facts, it wasn't supported by the record. I'll give you a few examples. There are facts in the district court's summary judgment order that were not submitted by the defendants, certainly not submitted by us. And the first time we saw them was when they cropped up in the summary judgment order, where the court cited to various allegations in our petition and deemed those to be judicial admissions, which we never had a chance to respond to. The court also called.
Were they wrong?
No, the district court accurately cited the allegations in our petition. That's not we're not saying the district court miscited the petition. We're saying it was there for the district court to, on its own, without giving us a chance to respond, say, you've alleged this in the petition. That's now a judicial admission. You can't respond to it or controvert it. And we see it for the first time in the summary judgment.
Are you saying that they're actually controverted? Are you arguing the procedural mechanism, or are you arguing the validity of the courts establishing those as undisputed material facts?
A procedural mechanism, certainly. I mean, I think the case law we cited stands for the idea that just simply because something is in the petition, an allegation, that doesn't make it a judicial admission. We're forever bound by.
Aren't you skipping a step? Wasn't there an admission by them that this was, by opposing counsel, that this was public property? So it wasn't the court reaching a conclusion out of whole cloth. It was the allegation plus the admission is what led to the court's conclusion.
Yeah, that's a different paragraph in our petition that you're talking about, Justice. On that issue, though, the defendant did admit that. We had made an allegation in the petition. They admitted it. And the court then deemed that as the basis for the judicial stop. Right.
Which fact do you think the court determined is actually an error of fact?
Well, the best example we cite to in our brief is the idea that the defendants didn't charge for admission for letters to access the property. We dealt with that extensively in the brief, but just to recap, the first place that issue came up was in a self-serving gratuitous statement that the defendants put in their answer. We didn't allege that in our petition. Never comes up in our petition. No witness ever testified about that issue.
Isn't that embodied, and I apologize, I don't mean to interrupt. Isn't that embodied in the concept of not doing anything to prevent the public from entering the hill? Access to the hill.
Your Honor, I think it's a completely separate issue. If you read the context of their answer, the way they slipped this statement in, it doesn't fit at all. We were talking about sledders accessing the property. They went further and alleged we don't charge admission.
Are you saying that they do? That's what I'm asking. You're controverting the fact that the court established, or you're upset that the court established an accurate fact?
There's no evidence in the record other than their statement whether the defendant did or did not charge admission to the public.
And you believe this is a material fact that precludes summary judgment, whether or not they charged?
The district court clearly found it to be a material fact. It cited that fact over and over and over in its order. The idea that the defendant didn't charge, so therefore it must be open to the public. Our issue is with the fact that there's no evidence other than their statement to support the idea that they did not charge admission. We contested that fact when it came up in summary judgment. It seems improper if a defendant can simply put something put a self-serving gratuitous statement in an answer and then cite to that as somehow being evidence to support summary judgment. If that's the law in Kansas, every doctor should start alleging I didn't commit malpractice in their answer, and then citing to that when
they do allege that in their answer.
But they don't cite that as a basis for summary judgment. That's not evidence.
Okay, so the basis for summary judgment, though, is you believe that this fact is material enough to warrant no summary judgment, is what I'm kind of getting at. The materiality of this fact, whether or not the court relied on it, but the actual materiality of it to your claim.
We think the court, yes, I think in our position is the court erred in the way it found the facts procedurally, and it was unfair. It didn't give my client an opportunity to respond. That's just one example. There are other examples, but the real issues in the case, the key issues, aside from the way the court found the facts, it's what the court did with respect to the two main issues. Was this open to the public? And is that something the court should have even decided, or was it a jury question? And did the willfulness exception apply? That's points 2 and 4 that I raised. On the first point I just mentioned, whether it was open to the public, for the life of me, I can't fathom how that's not a jury question. There was evidence.
It was admitted. Why would they submit something that both parties agree it was open to the public?
At the beginning of the case, we made that allegation and they agreed in their answer. The way the evidence developed, their own witnesses testified this was not public property. This was private property. And in fact, people were trespassing.
No,
Evidence in this.
no, not on the hill itself. There were portions of the hill where there were no trespassing signs, but there's no indication that the hundreds of people that used this for sledding were all trespassers.
The evidence in the record that the defendants pointed to does not make that distinction. It does not, that Mr. Beckley, Mr. Karp did not differentiate between public and private property, the sledding hill versus other portions of the property.
They specifically said that the trespassing signs only pertain to portions of the hill, which was not the portion that people used for sledding.
Defendant's counsel, though, he agreed in oral argument to the trial court that the sign that says no trespassing and no sledding is on the sledding hill. It's not on the portion where my client went down. He said it's on the sledding hill. But this interaction, this dialogue, this proves our point that how is this not a contested fact?
Because there was an allegation and an admission. It was no longer a contested fact.
True. But
Until your client alleged she was a trespasser later.
that developed after discovery brought that issue into the case. And the Kansas Supreme Court and the Court of Appeals has said the petition doesn't govern the case. The petition doesn't control all the legal theories in the case. The pretrial order does that. We hadn't gotten to a pretrial order in this case. Had we done so, it would have contained and spelled out this theory that had developed in discovery in the case. Facts that had come up after the amendment deadline, as you saw, the trial court had an issue with that. This came up after that. Their own witnesses talked about trespassing. The signs on their property that came up after the amendment deadline, after the petition was filed. So we think it's a bit prejudicial for us to, especially in Kansas is a notice pleading state. Our petition, how does that bind us forever when you file that at the beginning of the case before you know all the facts? Trespassing was an issue in the case. We talked about it in depositions. And for us to be precluded from arguing that simply because we didn't later go back and specifically use the word trespass in our petition, that seems unfair.
Well, it's a different theory. And once the theory tanked that it was public property, then she decided to go the angle that she was a trespasser. That's a totally different theory of the case.
It is a different theory, but I'm not aware of any Kansas appellate court opinion that says once our primary theory changes, we must go back and amend the petition to include that new theory. I am aware of Kansas Supreme Court cases saying the petition doesn't govern and it's the pretrial order that governs. And the theories and the legal arguments that are put in the pretrial order, that's what matters, not what the plaintiff first alleged at the beginning of the case. Especially when in a situation like this, it does come up after the fact. The trespass issue only came into the case after their witnesses brought it up, that this is private property. We don't want trespassers.
They don't want trespass. So your position is that it's an all or nothing proposition. The hill is either full of trespassers or it's full of public use, that there cannot be an isolated portion where they don't want trespassers. That's your position.
My position is that the record in front of the trial court didn't make that distinction. And there wasn't a basis for her to conclude that it was all or the other. It's a disputed fact. And a jury should have decided this. Maybe a jury would have found that way and said, you know what, this is clear. The sledding hill, that's open to the public, always has been. Over here, that's private. But that's a jury question. How can a trial court make that decision when clearly there are disputed facts at play on that exact issue? We think that was error. This is on the issue about whether or not the property was open to the public. You saw the evidence we pointed to, the signs that said no sledding, signs that said no trespassing. Defendants on witness testimony saying that they don't want trespassers on the property. At a minimum, again, we think that should have raised a jury question. There's a case we both cited to, both sides. Bingaman. Actually, there's a lot of cases we cited to. There's a case in Rhode Island, the Bucky case, exactly on point, where that court said, if you post a no trespassing sign, that pretty much automatically precludes you from arguing that the property is open to the public. But the Bingaman case, it's a 10th Circuit case, 1993. 4, maybe, where similar facts, injury on public property, or what's alleged to be public property. The district court grants summary judgment to the defendants, and if appeals, and the 10th Circuit reversed the summary judgment order, finding that it was a disputed fact issue about whether the property was open to the public, and reversed the summary judgment order. Now in Bingaman, the Court of Appeals pointed to several facts to support the idea that it was disputed whether it was open to the public. There were signs posted, there was a guard, some portions had fencing. Here, we don't have guards, there's no fencing, but there were signs. So what it's a matter of degree, right? In both cases, the defendant took some affirmative steps to indicate that the property was closed to the public, and here that more so that there was no sledding allowed. Again, Bingaman, if you read it that way, it supports our position. This is a fact question. This is not a matter that can be decided as a matter of law by the trial court.
But in Bingaman, the injury occurred specifically in the area where they were precluded from swimming. Your client's injury occurred in the area that was open to the public.
Allegedly open to the public, but what their witnesses and what the signs we indicate think there's an argument that it wasn't. And an admission by defendant's counsel that the sign we're talking about, one of the signs, there were several, was on the sledding hill on the western side of it. Seems disputed to me.
So you have just about 1 minute left, but could you address briefly the application of the exception, whether there was willful action by
Yes, thank you.
defendants? Yeah.
That's the second key point. Remember, there were two. Whether it's open to the public, and if it is open to the public, does the willfulness exception apply? We pointed to evidence produced in discovery where the defendant's executives discussed this exact scenario. We have to put hay bales out to guard against injury, including traumatic head injury. That's exactly what happened to my client. They used to put hay bales out. This year, they did not. The year at issue, they did not. If you read PIC 103.04, the willfulness statute, or willfulness instruction, and if you read the recreational use statute, what it says is that willfulness means an intent to injure or do wrong. Now, some of those emails, they're in the record, the defendant's executive said, putting hay bales out to protect against head injury is the right thing to do. But they didn't do that the year we're talking about. So it seems to me if you don't do what you admit is the right thing, you're doing the wrong thing.
But isn't there more of you're intending to do the wrong thing and that there's some sort of malicious intent?
I don't think that's how the cases or the instruction reads. It specifically says willfulness, intent to harm others or do wrong. And again, they said doing this, putting hay bales is right. It means if you don't do it, aren't you doing wrong?
So you're saying
Isn't that
by not putting hay bales, you're arguing that their intent was to harm people who went sledding?
No, no, Your Honor, because intent to harm, it's a separate issue. Intent to do wrong or intent to harm. There's two ways to prove willfulness under Kansas law. We can say that they intended to harm. We're not saying that. What we are saying is that they intended to do wrong. They knew doing this would prevent traumatic head injury. They chose not to do it this year. If you admit putting the hay bales out was right, how is not putting hay bales out? How's that not the wrong thing to do? Especially when they discussed, this is all ahead of time, before my client was injured, especially when they had specifically discussed what could happen if they don't put hay bales out. People are going to hit them and they're going to suffer traumatic.
So is it your contention then that the intent to do harm is a fact question and not a question of law?
Your Honor, I can't see how it's not a fact question. We cited the Kansas cases saying when it comes to intent, that's almost always a jury question, because intent, somebody's mental state, their state of mind, that's almost always proven by circumstantial evidence. So how is it not a fact question? How can a trial court, based on this record, come to the conclusion as a matter of law, no evidence of intent, and summary judgment's appropriate?
Well, what about harm?
What about
The definition of harm? Do you think that's a fact question or a legal question?
that would be a fact question, whether my client was harmed. But I do want to make that distinction. That statute is very clear, the instruction. Willfulness can be intent to do harm to someone, or it can be intent to do something wrong. We're not saying they intended to intentionally harm Stephanie Tucker Muir. We're not saying that. What we are saying is they knew putting these out was the right thing to do. They chose not to do it. That's the wrong thing. And you can prove willfulness by doing the wrong thing.
Okay, counsel, you're a minute or so, a couple minutes into your rebuttal, but I'll give the other side extra time, so. Okay, Appalee.
May it please the court. The district court properly granted summary judgment in favor of the defendants based on the protection from liability provided to them by the Kansas Land and Waters Recreational Areas Act. And I think it's important to note the stated purpose of the act, which is to encourage landowners to make land and water areas available to the public for recreational purposes by limiting liability towards persons entering thereon for recreational purposes. And notably, the legislature in 1995 amended the act, and what spurred that legislation was the desire by Wolf Creek Nuclear Power Plant to make available to the public only portions of its plant's cooling lake for public fishing, but to at the same time place warnings and restrict access to other dangerous areas of the exact same lake. So it's clear, subject to two exceptions, the legislature did not intend for a landowner to have to hold open for recreational purposes an entire lake. And we've cited the Genco case where it was a Connecticut Court of Appeals case, but the court noted that in that lake case, there were warning signs or, do not recreate signs near a waterfall overlook, which is obviously also public policy. We want landowners to open up their property for recreational purposes. But if there's a concern like a cooling lake on a nuclear power plant property, or, this lake has a waterfall, then the landowners are allowed to restrict recreational use in other areas. And it does not, as the Genco court said, give rise to a fact question, an issue of material fact that would defeat summary judgment. The court is to look at the area where the recreational purpose is permitted. Is it permitted there, yes or no?
Do you have a citation for that case handy?
Genco?
Yes.
Oh, I'm sorry, Judge, I don't have it. Connecticut Appellate Court 1986. And it is in our briefing. It's in our certainly in our reply in support of summary judgment and our brief as well. I apologize.
Thank you.
Let's assume that we understand and agree that parts of land can be held open while other parts are not. How is it not a question of fact as to which parts are open and which parts are not?
Well, in this case, there's no evidence giving rise to any genuine issue of material fact that the sledding hill, the defendants did not permit sledding on the sledding hill. And it's important to note the parties together agreed that the definition of, quote, capital S sledding, capital H hill, close quote, is this: the long, wide, grassy hill on the north side of the building that extends down to 108th Terrace. There is no evidence in this case that gives rise to any inference that defendants do not permit sledding on the sledding hill as defined by the parties in the pleadings and on summary judgment. It was uncontroverted. That's still the definition we're using. That's what we're referring to. And counsel mentioned counsel for Appalee's statement in the oral argument, which is page 31 of volume 2. Counsel stated the sign that is in the gully between two buildings, not on a long, wide, grassy hill on the north side of the building, is on the far western side. And it is clear from the photographs that those signs are not on the sledding hill. And there is a witness who was shown pictures of the sledding hill, exhibits 15 and 16 on plaintiff's summary judgment response, where Mr. Haney identified that is the sledding hill. The photographer is standing at the top of the hill. There's two different angles of the hill in each of those photographs. Mr. Haney identified them, confirmed that's the sledding hill. He was also shown the no sledding signs. And he testified, and his testimony is undisputed, and it's clear from the photos as well, and the map that plaintiff provided to the district court, that the photographs are by an easement driveway near an entrance to a building, 8205. That photograph does not show a long, wide grassy hill extending down to 108 Terrace. It shows immediately an easement driveway, a parking lot.
So how close would the sign need to be in order to make it undisputed that the trespassing sign was applying to this hill? Like, is this sign something that someone would have to drive by in order to park to get to the sledding hill, for example?
Well, there would have to be evidence in the case that gives rise to an inference of a genuine issue material fact as to whether the defendant permits sledding on the sledding hill. And the overwhelming, I mean, those signs don't raise that inference in this case.
Because they're too far away?
Well, because they're not,
They're not visible from the
not
hill?
an issue of not, of being too far away. They are not on the sledding hill.
So they would have to be on the sledding hill. Like, you would have to have a sign on like the top, the bottom, the side, like where on the sledding hill would the sign have to be to make it mean that you weren't supposed to trespass there?
Well, I don't know if there's a specific test as to how many feet, but it would have to be something that would infer that a person going there would say, oh, this long, wide, grassy hill where people have been sledding for 40 years, according to Dr. Beckley, and is a prime sledding spot, is an exceptional sledding spot known to those in our community, that's no longer allowed anymore. And those signs certainly do not give rise to that inference.
But how is that not a question of fact? If you can't tell me where the sign would have to be to make it obvious it was no trespass, then how is it not a question of fact about whether or not the location of these signs creates an inference?
The signs in these cases are clearly not on the sledding hill. They are not, in any relation to the sledding hill that would make people who are coming to sled on the long, wide, grassy hill extending down to 108th Terrace think that it's not allowed. And the only thing, this is also undisputed testimony in the record, is the only security guard request that is made of sledders is to please do not, if you're coming here to sled on the sledding hill, please do not park in our parking spots that are meant for patient parking in the driveway. Please park somewhere else. There is undisputed testimony that the defendant's employees have never been asked or advised or sat in on any communications about, we're going to tell people that they cannot sled on the sledding hill. We're going to direct people they cannot sled on the sledding hill. One of the employees testified that I've never been asked that. I would never tell somebody that. One of the witnesses testified that his Dr. Beckley's son and his grandson have gone sledding on the sledding hill. And in light of all of the evidence in the record, there's just no evidence that gives rise to an inference that for 40 years, the Cleveland defendants have not permitted sledding on the sledding hill. And they are permitted to limit recreation in other areas of their property. In addition, plaintiff took the position that that type of evidence, defendants had not submitted that to the district court. We did submit that to the district court. We've cited it in our appellate's brief that it's throughout our reply in support of summary judgment. And much of the evidence that defendants then cited to in the reply was evidence that plaintiff herself provided to the district court. So I don't think she can complain that, the evidence that she relied on and provided to the district court somehow does not support her position that there's a genuine issue of material fact as to whether defendants permit sledding on the sledding hill. And as far as the judicial admission, the court considered all of the evidence that plaintiff submitted and evaluated whether any of that evidence gave rise to an inference of a genuine issue of material fact as to whether defendants permit sledding on the sledding hill or whether defendants acted willfully or maliciously.
Can I interrupt you for just a second? And I apologize. Could you please respond to counsel's argument regarding perhaps the late insertion of a reference to not charging to use the hill?
Yes, Judge, and you picked up on our position in our brief is this is a situation where the plaintiff alleged in the brief or in the amended petition, defendants do nothing to prevent anyone from sledding. And pursuant to KSA 6208, defendants have a duty to fully and fairly respond to plaintiff's factual assertions in the petition. And if they're going to deny, they have to have factual, evidentiary support for that. And they have to specifically deny or they will be deemed to have admitted. So in fully and fairly answering that, defendants clearly admitted that they do nothing to prevent anyone from sledding on the sledding hill. And charge is defined in the act as a limitation on permission. So defendants included in their full and fair response to that allegation, factual assertion in plaintiff's amended petition, we do not do anything to prevent sledding on the sledding hill. We do not limit that to charge. The public is allowed to freely come out and sled on the sledding hill. What the court would not do is allow plaintiff to somehow in response to summary judgment, amend her amended petition, strike out factual assertions that we're now giving plaintiff heartburn in trying to survive a motion for summary judgment, or take the position, as Judge Isherwood noted, I have a new claim now. Forget that claim, forget that pleading. Just don't look at that. We're going with trespass now. We're saying the opposite of all the factual assertions, which plaintiff did not notice plead. She asserted over 61 paragraphs, much of which are fact after fact after fact after fact of factual assertions that the defendants allow the public to sled on the sledding hill. They know the public is doing it. It's on Google Maps. It's on YouTube. It's a prime sledding spot. It's known for exceptional sledding. So the district court, that is what the district court was not allowing the plaintiff to do. And that is proper. She never filed a motion for leave to amend. She never filed a proposed second amended petition where she or her attorney signed the proposed second amended petition stating, subject to KSA 6211, that they have evidentiary support for their new assertions that the defendants do not permit sledding on the sledding hill portion of their property. But the court still considered all the evidence that plaintiff submitted and evaluated that and discussed that in the journal entry, and correctly found it just didn't give rise to an inference that there is a fact question for the jury as to whether defendants permit sledding on the sledding hill or acted willfully or maliciously.
Before you run out of time, can I jump to the exception real quick?
Yeah.
If we were to assume that it applies, can you please respond to counsel's assertions that there were statements, and I don't remember if it was from Mr. Haney or Mr. Beckley, that it's the right thing to do, right? So clearly, if you don't, then the contrary is true. The counter is true that you were doing the wrong thing. Can you please respond?
Well, in order to get there, plaintiff has to argue for a less arduous standard than how willful has been defined by the Kansas Supreme Court in Anderson versus White, 1972, and Bowman, 1984, which are both after the Mathis case. That was not a willful case. That was a case where the court was looking to see whether the conduct of the defendant rose to reckless. It's clear that, Anderson versus White says it's conduct indicating a design, purpose, or intent to do wrong or cause injury to another. And in Bowman, I believe it's 1984, the Kansas Supreme Court said a willful wrong involved an intentional act and an intentional injury. And discussing, putting hay bales on the sledding hill in years prior, that it's a good, reasonable precaution or the right thing to do, that does not give rise to an inference that there was a willful or malicious, intentional decision to not put out hay bales on the sledding hill in January of 2021 during COVID, which the witnesses, that was the only reason they gave for the Cleveland employee witnesses. In addition, I want to just quickly point out the statute says if a landowner takes action to make a property safe, or to give a warning about a dangerous condition, use, structure, or activity, that landowner is given the protection of the act, maintains the protection of the act. And the legislature specifically said, if a landowner does not do that, that landowner is given the protection of the act. So for this court to then say, well, if you don't do it, you're not given the protection of the act, where we have something that is clearly not an intentional act, intentionally putting the hay bales out, not putting the hay bales out in order to do something wrong and hurt somebody and cause them to hit us.
Well, I think the argument isn't that by reversing the district court, the court would be saying you're not subject to the act or you don't get the benefits of the act. The question is this a question of fact versus a question of law? And as we've seen with cases recently, those can kind of conflate sometimes. It's difficult to determine what is a fact question and what is a law question. And so it wouldn't mean you wouldn't get the protections. It would just mean it's not a question of law. It's a question of fact that there's some dispute about, right? And so the question is it law or fact? And if it is fact, is it fully undisputed? That's the summary judgment standard. So what would your contention be? Law, fact?
My contention would be there is no evidence, zero evidence in the summary judgment record that gives rise to any inference that defendants acted willfully or maliciously. And in that case, even if you're dealing with something that is traditionally a question of fact, you have to have evidence in the summary judgment record that gives rise to that inference.
So undisputed fact.
Correct, Judge. And if you are saying, if the court, I mean, it makes no sense for the court to say, well, not putting out hay bales when you had in the past and you thought that was reasonable, no matter what the circumstances were, that it was COVID, that there was a concern about the focus is on educating during the COVID pandemic and operating during that time, January of 2020.
And that's a lot of weighing of evidence, right? You're saying, oh, if you consider COVID and if you consider this, and I mean, that's weighing of evidence.
Well, it's what it is doing is not advancing the purpose of the legislature's purpose of the statute, because the legislature specifically put in there, a landowner can do that or not do that, can take action or not take action, and they get the protection of the act. But then this court it doesn't make sense for this court to turn around and say, well, if you don't do it, that's an inference of willful.
Well, you don't do it, but you've done it before, and there's emails saying, I mean, it's not the same as do it or not do it. There's all these other things that you're asking us to consider in one way versus another way.
But doesn't it have to be a controverted material fact? I mean, everyone agrees that hay bales weren't there. Is the reason why they weren't there, is that material?
Well, the exception is there is no protection for a willful or malicious failure to guard or warn against. So, and there is no evidence in this case that gives rise to an inference that the not putting the hay bales, not having them out on January 2nd, 2021 was willful or malicious. Plaintiff has deposed 3 separate employees of the defendants. None of that testimony gave rise to that inference that is the reason they were not out in 2021. And the emails are discussions about putting them out, which the landowner can do or not do and still have the protection of the act. And just because you did it before, that doesn't mean that it's willful, an intentional act and an intentional harm that they were not put out.
See,
undisputed testimony.
So that's a question of law. So that's what I'm saying is that's more of a question of law of how to define willful, I think. So as opposed to a question of fact, as opposed in applying the facts to that.
Okay. Yes, Judge. You might be right. It's a hybrid.
Who knows? That one day someone upstairs at my office will say whether or not it's right.
And, it's particularly compelling going back to the amendment that, 20 years after Anderson was decided in 1972 and after Bowman was decided in the 80s, and the legislature amended the act to make clear that the act applies to even landowners who only hold out a portion of their property. At that point, the legislature could have said, I don't know about this court, Kansas court. This is, maybe that's not what we meant, or maybe that's too part of a standard. They did not do that. The willful or malicious standard remained in the act and has remained, which indicates, it's the legislature's position to tell us a different standard would apply.
But all of this really becomes a non-issue if we find that this was public property to some degree.
The act applies to private owners of non-agricultural land who directly or indirectly invite or permit any members of the public or members of the public to recreate on a part of the property or any part of the property or the whole property, whichever it may be. The exceptions, there's then two exceptions to the act, one of which is the willful or malicious, and the charge, which we, because charge is mentioned in the higher, earlier in the act, we just addressed it kind of up front. And there's no evidence, that anybody charged anyone. Even plaintiff didn't testify. She was asked to pay a fee. She was told she couldn't be on the sledding hill if she didn't pay a fee. Her sledding partner, Teresa Schrader, did not testify to that. They didn't testify. Their daughters were asked that.
Counsel, you have about 1 minute to wrap up.
Just to address the Bucky case that plaintiff's counsel mentioned in oral argument, that was a case that involved a social guest. It was, I think that's the case where the court says this is akin to a social gathering, a barbecue. It's not a situation. It was undisputed. There was no genuine issue material fact that the owner of that property was not holding, saying, public, come out here, use my cabin, hike the trails on my property, get in my lake. So that is distinguishable. And in Bingaman, there was testimony of security guards and sheriffs that people were forcibly removed from the Muir, and that they were fenced off. There were buoys put up to keep them out of that section. And that is certainly not what we have here on the long, wide, grassy hill, the sledding hill that extends down to 108th Terrace. We would ask that the court, from the district court's decision granting summary judgment, no genuine issue of material fact exists, that the act applies, and the exceptions do not apply. Thank you.
Thank you.
What Ms. O'Shea just said about Bingaman, I think that proves exactly what we're saying. This is a jury question. In Bingaman, certainly there was more evidence showing that it was public, but there is evidence here showing that it was private. It's a matter of degree, which means a jury should answer that question. This exchange, Your Honor, with Ms. O'Shea about how close the signs need to be, that's exactly the point. Standards set out by the Supreme Court say reasonable minds could differ. We get the benefit. Summary judgment has to be denied. In this case, for the only way the trial court's order stands on that issue is that you can look at the facts and the record and say no reasonable person anywhere could look at the testimony from the defense executives and these signs and come to the conclusion that the hill was closed to the public.
So what barriers, signs, or impediments did your client experience from her parking lot space to the top of the hill that indicated to her, I am not supposed to be here, but I'm going to soldier on?
The defendants pointed to nothing.
I'm asking what your client saw, because she certainly explained why she was a trespasser, why she perceived herself to be a trespasser.
Okay, there you go. What I'm saying is in the record, there's nothing that my client said indicates she herself experienced any barriers to walking straight up the hill and coming straight down. That's her. The sign we're talking about was a little ways to the west of where she went up and down the hill. But again, Is the trial court really the one who gets to make that determination? No reasonable person could come to the conclusion that a sign just over there, not where I walk up the hill, but a sign just over there that says no trespassing, no sledding, well, that area is private. This little lane I'm
Yeah,
walking.
that would be a question of law. That's when a judge says, absolutely not. This cannot be trespassing because it is too far away. Like legally, it wouldn't fit the definition of trespass.
So it's a matter of degree how close the sign is.
But does the sign matter when we have, news articles talking about this hill and how long it's been a sledding hill? And I mean, when there are those sorts of public attestations to, hey, look at this hill, this is where everyone sleds, is there really a reasonable question?
We think so. Absolutely. Absolutely. When the defendant's executives say this property, there are trespassers, it's not open to the public, there are signs saying that, we think a jury could have looked at that and should have looked at that. And some could have come to the conclusion that it's not open to the public. I'm not saying a jury's right would fine for us at trial, but we should have been given the right to try that. A jury should have decided. It's not Judge Mason. That's our position. On the issue about
But if that's the way you felt, I mean, clearly all of these signs, impediments, whatever, were in existence at the time. Why wasn't that your initial legal theory?
because we weren't aware of those signs. That was my point earlier about how we can't be bound by a petition filed a year and a half before we start doing discovery. That's just not fair. And that's not how the Kansas Supreme Court says notice pleading works. It was only when Mr. Haney brought up these signs, he was the first deposition. Mr. Beckley then testified, yeah, people are trespassers. This is private property. That's when the issue of trespass first came into the case. On this point, though, I have to point this out. This issue that, well, just the north side of the hill, that's open, everything else is closed. You will not find that argument anywhere in the summary judgment record. I've read it 10 times in the last couple of weeks. That argument was made for the first time at oral argument by defense counsel. There's nothing in the record that says only part of the hill was open, everything else was closed and was governed by these no trespass, no sledding signs.
So opposing counsel's assertion that there was an agreed upon definition of the sledding hill as this long, wide area on the north side, that's not an accurate statement?
The sledding hill, no, if you look at some of the photographs that are in the record, you'll see people going down all sides of this hill. The north, the northeast, the northwest, where the no trespassing, no sledding sign was.
Well, I'm asking,
Again,
she had said, opposing counsel said that the parties agreed that the sledding hill was a long, wide grassy area on the north side.
I'm not aware of any agreement to that effect. There was an allegation in the petition to that effect. There's an allegation, a statement of uncontroverted fact talking about the sledding hill. But that's all, it's one, if you look at it, it's one large hill that bends around from the east to the north to the west.
Your contention is that you didn't agree to the definition of the sledding hill?
We didn't agree that the sledding hill, Your Honor, was only the north-facing small aspect of this large hill surrounding the property. I mean, the record speaks for itself, and we're bound by what we agreed to in the summary judgment record. That's not my understanding of what we agreed to as defined as the sledding hill. On the willfulness issue, Ms. O'Shea mentioned that COVID was related to the placing of hay bales. Again, this is another issue we have with the trial court order. There is not clear evidence in the record that that's why the hay bales were not put out the year my client was injured. Mr. Haney testified that that may have had something to do with it, but it wasn't his call. It was Mr. Beckley's call. Mr. Beckley testified, well, it may have been due to COVID, maybe not. And he didn't even remember whether he made the decision or whether Mr. Karp made the decision. This is why we controverted that issue when they raised it in summary judgment briefing. We said there's no evidence that COVID was the reason hay bales weren't put out. And of course, the trial court found that that fact was uncontested by us.
You're technically over time, counsel, but if you just take a few seconds to wrap up.
Sure. One other point, Judge. I'll be very brief. On this point about willfulness, here's what the defendant's executive said. This is in the record, an exhibit to our summary judgment response. They said, taking obvious precautions to avoid potential traumatic head injury and protect the public, such as hay bales in front of light poles and fire hydrants on the sledding hill, is the right thing to do. The willfulness instruction, juries don't get instructed on what the Kansas Supreme Court says, they get a jury instruction. And 103.04 says that willfulness can be intending to harm somebody or doing wrong. If they're agreeing that placing hay bales is right, They make a decision not to place the hay bales. How does that not fit within the definition of willful as being something they did wrong? That was our whole argument. The trial judge may not have agreed with us. The jury may not have agreed with us, but a jury should have decided that issue. That's all I have. Thank you, Your Honor. We ask that you reverse the trial court.
Thank you, counsel. This case is now deemed submitted for decision, and we'll take the case under advisement and issue a ruling as soon as we can.